Hey y'all, I'm Karen Mayer Cunningham, the special education boss. If you've ever felt confused, overwhelmed, or just plain frustrated at the 504 IEP table, you are in the right place. Every week, I'm breaking down the rules, the rights, and the realities of special education so you can walk into meetings informed, empowered, and ready to make real change. And whether you're a parent, a teacher, an advocate, a school-based member, or somebody who's just trying to do right by a student, this podcast gives you straight talk, real answers, and tools that you can use immediately. I'm not here to play politics. I'm not here to play sides. I'm here to train people who sit at the table and teach you how to follow the law, ask the right questions, and protect the rights of students. So go ahead and hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change. We're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody. Okay, so going to pick up again. We're talking about due process hearing. If we haven't met, I'm Karen Mayer Cunningham, special education boss, training everyone that sits at the 504 IEP table to navigate and negotiate successful student outcomes. So we're picking up the last dispute resolution option for states, right? And so there's 4 of them. There is state IEP facilitation, there is mediation, there's a state written complaint, and there's a due process hearing. So let's talk about the due process hearing. I think that there's so many things that people know or don't know about a due process hearing. And I'm going to go in a little bit in depth because we have a really good guidance from the Texas Education Agency, and you can get this. If you just want to send us a message in the orange cart, the orange little block, I'll get you this. I'll send you this. So this is the Texas Education Special Education Dispute Resolution Systems Handbook. It's from the Office of General Counsel. It's really, really good. So if you would like a copy of that, I will get that over to you. But I think that you need to know some components of what a due process hearing is. Okay. I think often people say, well, I'm going to sue the school district. You're not really suing the school district. So let's talk about what this dispute resolution option is. It's a mechanism covered and protected for you under IDEA. And so these are the components that we're going to talk about in this part are as follows. 1, what is a special education due process hearing? What is the due process complaint? Who can file the complaint? How does someone file a complaint? What information must be included in the complaint? Is there a time period for filing the complaint? How must a party respond when receiving a due process complaint? Does a party need to have an attorney? May a party be represented by a non-attorney at a hearing? What is the special education hearing officer's role? Who are the hearing officers and what are their qualifications? How are hearing officers assigned to cases? Once a case has been assigned to a hearing officer, how do the parties file additional pleadings or other documents? May a party request that a hearing officer be removed? What is the resolution process? Who may attend a resolution meeting? What happens if the school district fails to hold a resolution meeting? What happens if the parents fail to reach an agreement at the resolution meeting? What happens if the parties do not reach an agreement in the resolution meeting? May a due process complaint be amended? Are discussions that occur during a resolution meeting confidential? May a party withdraw a due process complaint? What is the hearing timeline for the due process? May a party watch a hearing to prepare for the party's own hearing? What happens to the student while the case is pending? When is the pre-hearing conference? What happens if a party cannot attend the hearing when it's scheduled? What issues can be raised at the hearing? What are the party's rights at the hearing? What happens at the hearing? What's the difference between procedural violations and substantive violations? Who pays the attorney's fees? How is the hearing officer decision implemented? And may the parties appeal the hearing officer's decision? So I don't know if we're going to get through all of this today, but we're going to get through some of it, okay? So what is a special education due process hearing? And I'm just going to read it to you off of this TEA guidance. Again, if you want a copy of this guidance, just complete the orange box below and we'll get you a copy of it. So what is a due process hearing? A special education due process hearing is one of the dispute resolution processes available to parents and schools. A due process hearing may be requested by filing a due process complaint when a parent and the school do not agree about the identification evaluation, educational placement of services of a student with a disability, and or regarding the provision of FAPE to a student with a disability. So I really want to talk about that. These are the things that we disagree on, right? Identification, evaluation, placement or services, and an offer of FAPE. And so when a parent files a due process complaint, the IDEA regulations give the parents and the school an opportunity to resolve this dispute. If parties do not resolve the dispute, they may go to hearing, which is a legal process where the parent and the school present their case to a hearing officer, and who will issue a decision. The hearing officer issues a decision. A parent may also request an expedited hearing when there's a disagreement with certain decisions involving discipline. Okay? So in all my years of doing this, I've never filed an expedited complaint because when you file a due process, you're looking at, like I filed a due process hearing in December of 2024, and our hearing date is at the end of August. Our due process hearing is at the end of August. And so that will be live. So any of you are allowed to watch it. So if you're interested in information about the due process hearing dates, if you want to just fill out the orange box, we will get you that information. Or if you want a copy of this guidance that I'm reading to you from the Texas Education Agency, I will get you that. Number 2, what is a due process complaint? So to request a due process hearing under IDEA, a party or the party's representative must first file a due process complaint that meets the IDEA requirements in 34 CFR 300.505. 34 CFR, and it meets the requirements of 300.508. It's so important that you understand what your rights are. I have never ran into anybody at a school district that knows the requirements under IDEA, because school districts aren't reading this book. They're not teaching this book. They're not making it a requirement for principals, assistant principals, special education directors. Often you will have special ed attorneys there, and we'll save that comment for another day, okay? So you have to meet the requirements under IDEA, which must remain confidential. These requirements are expanded when a parent or the parent's representative files a due process complaint. The IDEA provides for a resolution period. And so the resolution period really is any time before we go to hearing. You can come to a resolution at any time, okay? Who can file a due process complaint? So a parent or a school district that includes the Texas School for the Deaf and the Texas School for the Blind and Visually Impaired. Again, this guidance is for TEA. If you want a copy of the guidance, just fill out the orange box. They, again, may file the complaint relating to any matter, including identification, evaluation, placement, or the provision of FAPE. So that really covers everything that you can almost think of. The party filing the complaint is called the petitioner, and the other party is called the respondent. So in Texas, we have annually about 600 due process complaints that are filed annually. Good news is that 95% of all cases settled. So the name of this book is the 300 CFR Federal Code. We have it in our link above or on our website, Special Education Academy. This is the federal law. This is IDEA, okay? So 95% of all cases that are filed in any court in America settle. That is good news for you. Now, certainly we don't want people out there frivolously filing, but you need to know how to file, and it has to meet those standards, okay? How does someone file a due process complaint? To file a due process complaint, a party must send a written due process complaint to the state education agency. And of course, almost every state education agency is going to have a model form on their website. Now, the party's not required to use the model form, but the states encourage it. The form is also provided on request by anybody. All regional education service centers and all school districts must provide that form. So if you are a parent and you're in an IEP meeting and you say to, Disney World School District, I would like a copy of the form to file a due process in the state of Florida, that school district would have to provide you that form. That a due process complaint must be emailed, mailed, hand-delivered, or faxed to the state education agency and the other party. the state education agency, and the other party. If you guys have a question, you can put a question in the orange little comment there. Today I'm just teaching, so we're not doing questions right here, but we'll get to them tonight. So, and you have to understand that you have to meet the federal requirements. So often when parents file, whether it's a state complaint, a mediation, they just sort of write down on a piece of paper their emotions about their experience at an IEP meeting. And so while I appreciate that, that is not going to meet the state standard to even open a state investigation. So again, it's paramount that you have this book, that you know what the federal law says. So you can go to IDEA, just type in the Individual Disabilities Education Act, and you can get this book from the government, or we have it in a link on our website. But this is the federal code. This is the Office of Federal Registry Code of Regulations, Title 34, Volume 2 of 4. Okay? And so, what information must be included in the due process complaint? This is what must be included. Again, you don't have to use the form for the state if you have an attorney. Obviously, make sure that if you have an attorney and you're going to file a special education due process complaint, that attorney is versed in special education. I see so many families that go out and they're like, oh, my Uncle Bob is an attorney. Special education is a beast. Any area of law has its own specificity. Any attorney worth their weight is not going to just ooch over into another category because they're an attorney. You have to understand how to file and what the obligations are. So, what information must be included in a due process complaint? Number one, the student's name, the address, unless the student is homeless, you would put that. Number two, the name of the student's school. Number three, a description of the nature of the problem and the facts relating to the problem, and a proposed resolution of the problem to the extent known and available to the party at the time. You know, one of the things I think is important for you guys to remember is that when we file a complaint, the state is not going to offer a resolution for you. They're going to respond to what you said your requested relief was. Requested relief. What does that language mean? Often the phrase requested relief is used to indicate what would return the student back to where they would have been had the IDA violation not occurred. So requested relief. So make sure that you understand what that is. You don't just file a complaint and go, yeah, let him have it. Okay, I don't know. I do know what let him have it is, but that's not a resolution. So when you go to file a complaint, when you go into an IEP meeting, you need to have a resolution, not just, ABC school district made me mad. You need to have a resolution and something that's reasonable. Because remember, almost all resolutions will be the burden of the school, but also the burden of the disabled child, right? If I heard somebody the other day that they got 1,500 hours in compensatory time. And I told them I thought that was terrible. I did. I just say what I think. Why? When is a disabled child going to make up 1,500 hours, right? So even if you had been denied 1,500 hours, a disabled child can't make that up. So you have to think of an idea, a proposal, a plan that is going to resolve the complaint, remediate the issue, but not burden the child that's disabled. So you have to have something that's reasonable, okay? All right, is there a time period for filing a state due process complaint to request a state due process hearing? Absolutely. So in our state, in Texas, a party must file a due process complaint within 2 years of the date that the party knew or the party should have known about the matter that is the subject of the hearing. There are two exceptions to that. One, if the parent was prevented from requesting a due process hearing because the school district specifically misrepresented that it was resolved. Or two, if the school district withheld information from the parent that the school district was required to provide under IDEA. Here's what you need to know. And this is one of the reasons that I implore you, to make sure that we get this done right. And Ruth Castle, if you'll just put in one of those orange content, I'd be happy to be on your podcast. But just fill out one of those little orange things and we'll get the information to you. I don't know why people wait. I don't know why people wait. If you think that your school district overnight is going to change their patterns, processes, and pathologies of how they implement IDEA, listen to me, love, you're probably mistaken. What we do at ABC Elementary School is what we do at ABC Elementary School. So you just being nice and taking a platter of cookies up there and laminating for the office ladies may not resolve your issue. So there are timelines in these, right? So an IEP facilitation can only come at the end of a disagreement. A mediation is for a year. A due process is for the last 2 years. Do not wait, and make sure that you've captured your position at the end of every IEP meeting. Because when you go to these, to trigger these dispute resolution options, the fact finder, the hearing officer, the state attorney, the state investigator is going to look at what? The paperwork. So complete the paperwork. Put in your position in the paperwork. Okay? So how must a party respond when receiving a due process complaint? So the party who receives the complaint must respond within 10 days of receiving the complaint and must specifically address the issues raised in the complaint. The school district is not required to respond to provide a response if the school district already provided the parent with a written notice that addresses the issues in the complaint. If the school district is the party responding to the complaint and has not already sent the parent a prior written notice addressing the same complaints, issues, the due process complaint, then it is sent a parent response that includes the following. So in all the years I've been a part of due process complaints, always the school district attorney is going to have their legal response. I've never had a school district not respond, but I'm sure somewhere that happens. So here's what would be in the response. 1, an explanation of why the school district proposed or refused to take action raised in the due process complaint. Number 2, a description of other options that the IEP considered and the reason why those options were rejected. Number 3, a description of each evaluation procedure, assessment, record, and report the school district used as the reason for the proposed or refused action, and a description of any other relative facts. So, and these are legal filings. And so make sure that it's not a run-on. If you're a parent and you're representing yourself, which you're legally allowed to, just know that you're going up against school district attorneys who are versed in responding to these things, okay? Does a party need to have an attorney? So this is the $64 million question. Does a party need to have an attorney? No. The parties to a hearing may represent themselves or seek to have a non-attorney, such as an advocate, represent them. This is specific to the state of Texas. Because of the legal nature of the proceeding, however, parties are often represented by attorneys. As required under federal regulations, the Texas Education Agency maintains a list of free or low-cost legal service providers. The list is sent to parents who request a due process hearing and also available at request on our state's website. The Texas Education Agency also maintains a list of parent attorneys and advocates that are sent to all parents requesting a hearing. This is also available upon request. So in the state of Texas, we have a list of special education attorneys and special education advocates. Does that mean they're great or amazing? It means that they're on the list. That's what it means. The hearing officer may not give either party legal advice or help parties present evidence during the hearing. A party without legal representation is still responsible for knowing the laws and the rules that apply in the hearing, which may include the following. The Individuals with Disabilities Education Act of 2004. This is the Individuals with Disabilities Education Act of 2004. This book is the Individuals with Disabilities Education Act of 2004. This is IDEA. So if you don't have it, get it, okay? Next, they're required to understand federal regulations of implementing IDEA, the Texas Administrative Procedures, the Texas Education Code, Texas Education Code rules concerning special populations, the Texas Education Hearing Rules, including the Commissioner's Rules concerning special education, Texas Rules of Civil Procedure, and Texas Rules of Evidence. So that's a pretty big obligation. I am allowed to represent families in Texas in due process hearings, and it was a lot of work learning those things. And so I'm very honored that for the last 11 years I've been allowed to represent families in due process hearings, but it is quite the burden. It's quite the burden emotionally, intellectually, especially if you're not an attorney. That's not something that you do every day. So if you have the opportunity and the resources to get representation, an attorney in a state due process hearing, I would certainly encourage you absolutely to do that, okay? May a party be represented by a non-attorney at a hearing? Now, this is specific to Texas. So Texas law generally allows a party to be represented at a special education due process hearing by a non-attorney if the non-attorney has special knowledge or training with respect to the problems of children with disabilities. The non-attorney must also meet certain qualifications, including the requirement that the non-attorney know about special education due process rules, hearings, and procedures about special education laws. Okay, so special education, due process rules, hearings, and procedures about special education laws. Okay, a party who wishes to be represented by an individual who's not an attorney must file a written authorization with the hearing officer on a form provided by TEA, which is available at the state. It is used for the hearing officer to determine whether someone meets the requirements to serve as a non-attorney represented in a hearing. If the non-attorney has ever worked for the school district that is the party to the hearing, state law allows the school district to object to the non-attorney's representation. If this occurs, a non-attorney will not be allowed to represent the parent in the hearing. So if you're a teacher at ABC School District and you retire and you come and let me train you to be a special education advocate, which of course I would love to do, and you have a client in a school district that wants to file a hearing, the judge is going to let the school district file their reason for not having you, and you probably won't be allowed to do that. Additionally, as a non-attorney advocate, it's very likely that the school district is going to object to you being their representative, period, whether you had all the qualifications in the world. So in the 11 years that I've been representing families in due process hearings in Texas, probably half of them, the attorneys, object to me being their non-attorney representative in a hearing, but I've never had a judge allow that. The judge always, in the past for me, has always overruled that and allowed me to represent the families based upon my knowledge and years of doing this. Okay? All right, number 10, what is the special education hearing officer's role? What is their role? The hearing officer is in charge of the due process hearing, just as a judge is in charge of a trial. The hearing officer controls the hearing, listens to the evidence and the arguments of the parties, and writes a final decision and an order. Additionally, the hearing officer calls administrator oaths, call and examine witnesses, rule on motions, objections, determine the admissibility of evidence, maintain decorum, schedule, and recess the proceedings from day to day, and any issue and other necessary orders, including sanctions, needed to maintain an orderly hearing process. The hearing officer typically has telephone conferences with both parties before the hearing to develop a schedule for the hearing process and to discuss any legal matters that should be addressed before the hearing. These conferences are referred to as pre-hearing conferences. So a lot of things go on if you are a non-attorney representative for the family, and you can't be doing this learn as you go, because when you get, you might get a subpoena. You might get a subpoena, your clients will get a subpoena from the school district asking for all of these things, right? And you need to know what is the requirement for submitting them. How do you submit them? In Texas, we have switched to an online system where you have to upload all these documents into this portal, which is so super friendly, said no one. You have to get exhibit books to all parties. So if I'm the non-attorney representative, I'm going to have a set of exhibit books for myself. I'm going to have a set for my parents, my client, right? I'm going to have a set of exhibit books for every witness that I'm going to call. I'm going to have a set of exhibit books for the school district attorneys, and I'm going to have a set of exhibit books for the hearing officer. That in itself is a lot of time-intensive work that has to be submitted in a certain way, in a certain order. Also note that those exhibits, as we start the hearing, if they're objected to by the opposing party, then you have to, legally support why they should be allowed, if they are legally sound. It's a lot. So I loved doing it, and I've loved being able to support my families in doing this. But it's certainly a different wheelhouse than being a special education advocate every day. Okay? So number 11, what is the hearing officer's role and what are their qualifications? Again, if you want a copy of this dispute resolution handbook from Texas, just fill out the orange card and we'll get you a copy of it. It's an amazing resource wherever you live in the United States. What are the hearing officers and what are their qualifications? Well, the state maintains a pool of hearing officers to conduct due process hearings. The pool consists of a combination of private attorneys and attorneys employed as administrative law judges, ALJs, administrative law judges. This is going to be an administrative hearing. This is not a civil hearing. This is not a family court hearing. This is not a criminal trial. This is not, CSI Miami. This is not Law and Order, although it may feel like it. Yeah. So you want to make sure that you are prepared to participate correctly in an administrative hearing. Okay. The certain SOA ALJs, State Office of Administrative Hearing, administrative law judges have been approved to serve as hearing officers in due process hearings. So often the due process hearing officers and the mediation officers for your state are the same. At minimum, they're all going to be what? Attorneys, right? Because you couldn't be a mediator for the state as it relates to this, or a hearing officer without being an attorney, okay? All right, so the state maintains a list of current hearing officers. They also maintain a list of their mediators, okay? How are hearing officers assigned to cases? So this is really, really important. You get who you get. It's not we don't like, hearing officer Jones and we want somebody else. It doesn't work like that, okay? The state assigns cases to hearing officers based on a rotation system. Under this system, the Texas Education Agency assigns cases to hearing officers who are private practice attorneys on an alphabetical rotation and assigns cases to state office administrative hearing according to the line practices specific to the interagency agreement between the Texas Education Agency and SOA. When TEA assigns a case to SOA, SOA then appoints one of the officers to the case. If a hearing officer is available or declines the assignment, the state will assign the case to the next name in the rotation. An exception to the rotation process is when the parties to the hearing were involved in another hearing that was filed within the last 12 months. In these situations, TEA will generally assign the recently filed case to the same hearing officer who presided over the previous hearing. In addition, TEA will generally assigns cases involving siblings that are filed on the same date to the same hearing officer, right? Excuse me. So that does happen. If you have, this happened to Michael Smith, and then the parent finds out it's also happening to Sarah Smith and their family, the hearing officer, because there will be same components, same documents, same evidence, same accusations, allegations. Remember, the person is filing allegations, and so the hearing officer is there to make it a ruling and decide on that. Next, what happens after a hearing officer is assigned to the case? Okay, so what happens after a hearing officer is assigned to a case is that the state will send parties a written notice that provides you with a docket number, hearing officer's name, and contact information. If the case has been assigned to a hearing officer, SOA also provides that docket number. They will send the parent a packet of helpful information that includes, again, what we talked about, the free and low-cost legal services, special education advocates, and attorney list, as well as a copy of this handbook. So again, if you want a copy of this handbook, just fill out the little orange card and we'll get you a copy of that. Okay. They will also the hearing officer will provide the parties the receipt of written notice, including a scheduling order. It will provide you a scheduling order. That's important to know what that is. That it identifies several deadlines, including peer hearing conferences, hearing dates, a decision due date. Further, the hearing officer will provide instructions on how to file pleadings with that particular hearing officer. If the officer has been assigned to the case, the officer will also provide options for non-represented parents to opt into an electric filing system or use other filing court options such as mail, fax, or hand delivery. And so I'm going to stop there because that's been a lot of information. If you have questions about your dispute resolution options, if you just fill out the little orange card there, and that will go out to our office, we will get you a copy of this. We want you to know what your dispute resolution options are, and we hope that you never in your whole lifetime ever disagree with anybody at an IEP meeting. If that happens, congratulations. That's not my experience. It's, again, disagreement is part of the human experience. Have you ever tried to figure out how to go to lunch after church with your family? That's, disagreements are normal. There's nothing wrong with disagreeing if you're a school-based member. There's nothing wrong with disagreeing if you're the parent. And so I want you to get out of this, I've got to be friends with them and get along all the time. We certainly want to get along with people, but when we're talking about educating a child with a disability, every person at that table has a different purview. That's why there are 5 stakeholders, right? The parent, who's considered the expert, the LEA representative, the local education agency representative, which is almost always a principal or a counselor or an assistant principal, the general ed teacher. Why? Because every student is a general ed student, period. The special educator, because these are students that receive special education student, related service provider, and or somebody that can understand and interpret and answer questions about assessment. So understand what your rights are, although there are many. So we want you to get this book. This is in our link above. You can get it. You can get it on the government's website. It's under ed.gov, departmentofelducation.gov, or you can go to our website. It's a link, or just send us a little question and we'll get you the link to get this. I think it's $40. But this is IDEA. This is the Individuals Disabilities Act reenacted in 2004. If you don't have it in your school, it's unlikely that people have read it. And if people at your school haven't read it, it's unlikely they understand what it says. And so that's why we're always going to be training you. Again, we always want you to join us on Special Education Academy, which we train every Monday night at 8 p.m. Central. And then additionally, if there's anything we can never help you with, just shoot us an email at advocate@specialeducationacademy. Remember, we get it right for the child. We get it right for everybody. And we are here to help you get it right for the child, however you sit at the IEP table. And we'll see you guys in the next training. Hit subscribe, share this with a friend, and you know what? Meet me back here every single week. We're not just talking about change, we're making it. Because when you know better, you do better. And when we get it right for the child, we get it right for everybody.